Blake Lively is scheduled to be deposed on Thursday, July 17th in New York City. The deposition is part of her ongoing lawsuit against Justin Baldoni, stemming from allegations of sexual harassment and retaliation on the set of their film It Ends With Us. Lively is also suing Baldoni's publicists, accusing them of launching a smear campaign against her following the alleged incidents. Baldoni has denied all allegations. In response, Baldoni filed a countersuit against Lively and her husband, Ryan Reynolds, citing defamation and extortion. A federal judge dismissed Baldoni's counterclaims in June. The judge did not grant permission to amend or refile those claims. Legal teams from both sides have since focused on the deposition phase. On Friday, July 11th, Lively's attorneys filed a motion seeking a protective order. They requested that the deposition take place at a redacted, secure location instead of Baldoni's legal team's office. The filing also asked the court to require prior identification of all attendees. Lively's lawyers cited safety and privacy concerns, stating that holding the deposition at Baldoni's lawyer's office would expose Lively to paparazzi and unauthorized individuals. The motion referenced previous actions and public statements from Baldoni's attorney, Brian Friedman. In May, Friedman suggested that Lively's deposition be held at Madison Square Garden. He proposed selling tickets or streaming the event to raise funds for organizations supporting domestic abuse victims. Lively's team cited this proposal as an indication that Baldoni's camp intended to turn the deposition into a public spectacle. In their filing, Lively's lawyers wrote, "The high-profile nature of this litigation and the nature of Ms. Lively's retaliation claims demonstrates a substantial risk of the deposition turning into a publicity event and potentially attracting interested individuals who could pose security risks." They further claimed that Baldoni's legal team had refused to meaningfully address concerns over harassment and intimidation. The motion also stated that defendants have used even the prospect of Ms. Lively's deposition to generate press interest since the beginning of the case. Lively's legal team argued that the court should prevent any attempts to manufacture a harassing publicity stunt or create conditions for intimidation or harassment. The protective order was described as a reasonable step to prevent the risk of annoyance, harassment, and verbal or physical threats. Baldoni's legal team filed a response disputing these claims. They argued that Lively had not submitted any evidence demonstrating the risk of paparazzi ambush or harassment. They emphasized that the offices of the two attorneys are only about a mile apart in New York City. According to Baldoni's lawyers, the proximity makes the concern of public exposure speculative and unsubstantiated. The response also stated that holding the deposition at Lively's lawyer's office would place Baldoni's team at a disadvantage. They referenced the volume of material involved in the case, including hundreds of pages of notes, and indicated the need for private consultation space during the deposition. The filing stated they'll need a conference room of their own mid-depot to chat in private. Baldoni's team insisted that the deposition should occur at their office, which they asserted is supported by the federal rules of civil procedure. The filing continued. Although Lively's foot-stomping and use of her celebrity status may have enabled her to seize control of the film, which is the crux of this dispute, her counsel's tantrum has no place in this court. Baldoni's team further stated, Lively is bound by the federal rules of civil procedure like every litigant. Friedman reiterated his stance during a TMZ live interview on June 10th. "I'm going to ask her questions under penalty of perjury, and she's going to have to provide evidence, and she's going to have to provide the truth of the stories," he said. He added, "We're going to see how consistent her testimony is with the actual facts of what transpired." He confirmed that his team has video footage, emails, and text messages, which they believe will be crucial in the deposition process. Lively's representatives released a statement to People on July 11th addressing the MSG proposal and the broader context of the deposition. Ms. Lively is looking forward to her deposition next week, and it should follow the same rules as every other witness in this case. The statement continued, Justin Baldoni's lawyer has tried to make this matter a public spectacle at every turn, even proposing to sell tickets to a televised deposition at Madison Square Garden. This is a serious matter of sexual harassment and retaliation, and it deserves to be treated as such. The statement emphasized that the intention of Baldoni's legal team to stream or ticket the deposition contributed to an atmosphere of undue publicity. Lively's legal team requested that the court intervene to prevent any scenario that might compromise the integrity of the legal process or her safety. The filing accused Baldoni's legal team of declining to guarantee restrictions on who could attend the deposition. Lively's lawyers alleged that Baldoni's team might invite media figures or social media influencers to increase visibility or exert pressure during the proceedings. The motion stated, Baldoni's legal team has not denied that their intent is to manufacture a harassing publicity stunt by requiring Ms. Lively to parade through paparazzi or by inviting unknown attendees to the deposition. Lively's team argued that without a protective order, the risk of harassment and security breaches remains high. Friedman has maintained that his client's legal rights must be preserved and that the deposition should proceed according to standard civil procedure. In his statements to TMZ and court filings, he emphasized the importance of examining Lively's testimony in light of available evidence. Following the dismissal of Baldoni's counterclaims in June, both parties are preparing for trial. The trial is scheduled to begin in March 2026 in New York. Attorneys for both sides have confirmed that their clients intend to testify. Lively's attorney, Mike Gottlieb, stated in May, "The ultimate moment for a plaintiff's story to be told is at trial. We expect that to be the case here with Lively, so we would of course expect her to be a witness at her trial. Of course she's going to testify." Media coverage surrounding the upcoming deposition has focused on the opposing strategies employed by both legal teams. Baldoni's side argues that they are acting within the scope of procedural fairness. Lively's team claims the opposite, asserting that her celebrity status is being weaponized against her and the process is being turned into a spectacle. People, TMZ and Page 6 all reported on the filings and responses from both camps. Page 6 noted that neither side responded immediately to their requests for comment following the latest court motions. People reported that Lively's team filed the protective order in direct response to Friedman's MSG proposal and the escalating media attention. Lively, 37, and Baldoni, 41, remain central figures in the legal proceedings, and both parties have escalated their filings in advance of the deposition. Baldoni has consistently denied the harassment and retaliation claims. He has not publicly addressed the judge's dismissal of his counterclaims. Lively has not commented beyond her legal team's statements. The parties are expected to adhere to the court's ruling on the location and structure of the deposition, pending the judge's review of the motion and response. As of the most recent reports, no final decision on the deposition location had been disclosed. Brian Friedman's earlier proposal regarding Madison Square Garden remains part of the broader controversy surrounding the deposition. Hold the deposition at MSG, sell tickets or stream it, and donate every dollar to organizations helping victims of domestic abuse, Friedman told People in May. Following Lively's July 11th filing, her representatives maintained that the deposition should proceed without theatrics or media involvement. Her lawyers framed the motion as a procedural safeguard designed to protect their client from unnecessary exposure and interference. "We have all of the videotape, all the footage," Friedman told TMZ Live. "We have, the text messages, and we have emails." According to his team, this evidence will serve as the factual baseline for cross-referencing Lively's testimony during the deposition process. As it stands, the court has not yet ruled on Lively's motion for a protective order. Attorneys on both sides are awaiting that determination before finalizing logistics. The motion and Baldoni's response both remain publicly accessible via court filings and press coverage. The trial date, set for March 2026, places the deposition at the midpoint of a lengthy and high-profile legal dispute. Both sides have stated their intent to testify, and each has taken public and legal steps to shape the narrative ahead of trial.